This program is made possible with funding from the Investor Protection Trust, the State of Alaska Division of Banking and Securities, and AARP. You may think that estate planning is only for the very wealthy, but if you want to ensure your assets and prized possessions are given to those you care about, as well as your medical care handled in the way you prefer, estate planning is the answer. Now here's your host, Ann Seacrest.
Hello everyone and welcome to AARP Alaska. Estate planning is not just for the very wealthy. It's also not just about money. Estate planning can also assure that your family members know how you'd like your financial and medical affairs to be handled if you become incapable of making your own decisions. Today our guest is Kevin Sullivan, an attorney who works in estate planning for Baxter, Bruce & Sullivan, a law firm in Juneau. Welcome to AARP Alaska.
Thank you, Ann. I'm happy to be here.
Pleasure to have you. We've got a lot to talk about in 30 minutes, so let's get right to it. Let's start, first of all, with the definition of estate planning. And what I'd like to do is simply read the 4 points of the definitions, and then we're going to talk about each point. First of all, control property while I'm alive and well. The second point is to plan for myself and my loved ones if I become disabled. The third point is after death to give what I have to whom I want, the way I want, and when I want. And the fourth point is to save every tax dollar, professional fee, and court cost legally possible. So let's start at the top and let's address the control property while I'm alive and well.
It's about title. Title controls how we own things. So we undertake a little due diligence and determine if we really do own the things that we think we own, the way that we think we own them. For example, 2 people might have owned a cabin together years ago and one bought the other out, but the deed did not get conveyed properly, etc. So it's a matter of going back and looking at each bank account statement, each title, each deed that memorializes your ownership of the assets that you have and determine if they are correct. And if not, address that issue.
The second point is to plan for myself and my loved ones if I become disabled.
Is the planning in place to allow the person or persons that you've selected to act for you to control your financial affairs, and have you given them the scope with which they can act? For example, if I'm incapacitated, a general durable power of attorney might be employed to select an agent, and that agent then can control my financial affairs, pay my bills, if my home needs to be sold, decisions need to be made with my retirement accounts, they can do that, etc. If I'm providing for an elderly parent, if I have dependent children, is the scope of that document sufficient so it's clear that that attorney in fact has the ability to expend my resources for the benefit of those persons, etc. And then to the degree that I've named someone, if they're unable or unwilling to serve, have I named a successor to them?
The third point is after death to give what I have to whom I want, the way I want, and when I want. So we're not talking about money necessarily. We're talking about possessions.
We're talking about the people that are most important to us and providing a legacy, a direction to them that's going to be in their best interest. It might be very simple to just say, I've got 4 people I want to provide for, so whatever I have at the end of my life, divide it in 4 ways and pay it out. But is that really the way it should go? For example, some of our loved ones may have substance abuse issues, may have creditor issues. To distribute a large amount of money or any amount of money to them might do them a tremendous disservice. Some of our heirs might be in a marital situation that may not be in their best interest. And if you distribute that money to them and then they're influenced by their spouse, and then half of your inheritance to that person ends up going to a future son-in-law or daughter-in-law, for example. Maybe there's special needs people that we're planning for, a special needs child, and distributing those assets outright, they can't administer them, or they can't administer them in a way that is in that person's best interest. So it's planning for each individual heir based upon the circumstances that they find themselves in, and then matching that with your goals and objectives, so you have people planning with regard to each distribution.
And it's certainly a matter of control, too, when we're talking when I want, to whom I want.
Absolutely, putting those provisions in place.
And the fourth point is to save every tax dollar, professional fee, and court cost legally possible.
Saving taxes,
Saving
everybody
money.
likes that,
Yeah.
absolutely. And that can be a number of things. It could be income taxes with regard to properly structuring our retirement accounts so our beneficiaries can stretch that out over their remaining lifespan, required minimum distributions. Stretch out provision, maybe it's income tax planning with regard to the Alaska Community Property Act. Maybe it's estate tax planning. With regard to professional fees, is the planning in place like general durable power of attorney that we talked about, so that if I am disabled, that instrument can be employed as opposed to having to go through a proceeding to have a conservator appointed, etc. So it's proper planning with regard to documentation and proper organization so things can proceed in the most cost-effective and efficient way possible.
All right, let's get right to the nitty-gritty here and talk about the actual estate planning process. And we've got 3 bullet points up, and I'm going to talk about them, and then I want you to address them. The first bullet point is family and loved ones, and the second bullet point is assets, and under that we have determine what you own and how you own it, and the third bullet point is goals and objectives, and there's a breadth and depth of information behind each bullet point. But under the process, let's start with family and loved ones.
Family and loved ones, who are we planning for? Who's most important to us? We love all of our children equally, but they're all very different people, different skill sets, different positions in life, etc. So plan for them accordingly. And it's not just family, it's those that are close to us and that we want to provide for. So figure that out, and that's part of the process, the counseling process of working through that to determine who you want to plan for and how you want to plan for them.
And then the second point is assets. Determine what you own and how you own it.
We touched on that a little bit just a moment ago. But actually doing the due diligence to take a look at every bank statement, brokerage statement, every beneficiary designation, every title to a motor vehicle, with regard to retirement accounts, if you're receiving retirement interest now, perhaps through a defined benefit program, have you elected a survivorship benefit? If so, does your spouse know that that's in place, etc.? So taking a look at each individual document, each individual asset, and making sure that it's structured the way you want it to be structured, so you know how it will be controlled upon your disability, you know how it may be directed upon your death, and if there's adjustments that need to be made either to avoid problems or to capture opportunities, then you can address it at that time.
And an important point here is to make sure that things are current.
Absolutely.
Yes.
This is often the case. Perhaps I worked with an employer years ago, and I left my retirement account there. And my beneficiary at that time was my brother. But now I'm married, and I have minor children. And brother and I, things are different now. So estate planning is a process. You go through it, and then you have to maintain that. So you put it in place as if you're going to need to rely upon it then, and as your life changes, then you make sure that you adjust your plan accordingly so that if you need to rely on it at any particular time, it'll work the way that you want it to work, both with regard to disability and postmortem planning.
Do you advise, is there any key thing as far as how often people should look, as far as the assets, should go back and review their records?
I think so. 5 years is sort of a benchmark for me. But if you're attuned to the process, you you won't need to wait 5 years. If I change jobs and I'm now having to complete new beneficiary designations, then obviously that's something to deal with. If I've purchased a life insurance policy, if I'm investing in a new retirement vehicle, etc. So just be mindful of the fact that you have this planning in place and you need to maintain it. It's not something that you do once, put it on the shelf, and never visit again and think, oh, when I need to rely on this 45 years from now, everything will work just fine because I took care of it way back then. Not the case.
Not the case. And the third point under the process is actually huge. In preparing for this program, I've learned so much under the goals and objectives.
Yeah, the issue there is, what are we trying to accomplish? Oftentimes people will come in and they say, I'm wanting to plan for my minor children, or if I predeceased my parents who are now dependent upon me, I want to plan for that. Maybe they want to make sure that things are in place so that their surviving spouse will be taken care of in an appropriate way. Maybe they're trying to plan for survival of the family business or a special needs child. And so I've put together over the years a list of goals and objectives, and it just gets people thinking. And then we go through them, and if they're unimportant to you, we won't focus on them. But if it causes you to think about something you had not thought about before that might be important to you, or if there is something there and we can flesh it out and put some meat on those bones and really understand what your objectives are, then we can focus on that so that the plan is crafted to meet the individual's circumstances, goals, objectives, matched with the characteristics of their beneficiaries and the assets that they actually individually own.
Because the goals and objectives really tie into values, don't they?
Absolutely. What's important to you? How do you want things to go once you're not here to take care of things yourself? So it's a tremendous act of love. It's what responsible people do. We all are going to die, right? Studies have shown that. So it's really just a timing issue. So let's get ready for it, and then when that situation occurs, things will move or progress in a proactive way as opposed to a reactive way.
Right, and it's also really some soul searching that people have to do, because they have to almost assign the rating that you say, rate it from 1 to 10, because that's the goals and objectives is aligned with their value system. So there's some soul searching that the individual really has to do. You know, is saving on taxes more important than, the minor child, or the minor child is, in other words.
Absolutely.
Yeah.
This is what is important to you, and it's just an opportunity to plan for that in a particular way. Like you mentioned, taxes. It's not about taxes. It's not about money. It's about people planning.
Right.
So what is important to you? What are your values? How are you going to pass those on in a way that makes sense for you to those you love?
When we come back, we'll have a checklist of what you need for a basic estate planning toolkit right after this.
Nearly 70% of Americans do not have a will. 10% of adults say it's because they don't think about dying or becoming incapacitated, and nearly 25% of adults say their biggest reason for not having an estate plan is a lack of sufficient assets. But estate planning is about letting your family know how you want your assets handled, as well as your medical affairs. Visit AARP's website at www.aarp.org/families for a free, useful guide on estate planning. You'll be able to download a will preparation worksheet. Do it for your family.
Now, because so many Americans do not have a will or have not done the estate planning, I have to go to this next slide, because it's what if you do nothing? And this next slide, and I'm going to read this, and then again I want you to react. If you do nothing, the law already has a plan in place. Second bullet, conservatorship. In the event of disability, a court may appoint a conservator to administer your affairs. Intestacy, upon death, direction of assets determined by intestacy laws, which determine how and to whom your assets will be distributed. So let's talk about that first point. The law already has a plan in place.
The saying is, if you don't have an estate plan, The state has one for you, and that's the law of intestacy. And basically it works its way through the family tree in terms of who has priority to the decedent and how those assets should be distributed.
So complicated if there's remarriage and so on and so forth.
All of that,
Yes.
absolutely. And then while we may be related to someone, maybe we do not want those assets necessarily to go to those people in that particular amount, in that particular way.
Got it. Second point, conservatorship.
That's the disability issue. If we have proper planning in place, which we talked a little bit about before, durable power of attorney so someone can make economic decisions for us, an advanced care directive, HIPAA release and authorization, for example, so someone can make healthcare decisions for us, then if we're unable to act for ourselves, that planning is in place and it can be implemented by the people we've elected. If we have no planning and now we're disabled, then we have to go through the process to have either a conservator appointed to manage our financial affairs for the person that's unable to do so, perhaps a guardian appointed to make decisions for the betterment of the person, etc. And then you're not making the decisions for yourself. You're asking a court to do that after going through and evaluating testimony, etc., with regard to who would be the appropriate person. So avoid all that, be proactive, make the decisions yourself, and put them into place so that things go the way you want them to go.
And then the final, if you do nothing, intestacy. Let's talk about that for a moment.
That's the family tree issue. And yeah, we have marriages, we have second marriages, we have children from the first marriage, we have surviving spouse, etc. And many of our family members from our heart are not our biological family members. So it's a simple distribution process if you don't have a plan in place. They just look at the family tree with regard to, are you married? Do you have descendants? Meaning, are you married? Are you survived by a surviving spouse? Do you have descendants? If not, are your parents alive? Siblings, nieces and nephews? This is the scenario where my distant uncle died. I haven't seen him in years, and now all of a sudden I got an inheritance. So if that's not the way you may want things to go, then you can implement some planning yourself and be specific about, again, who you want to distribute things to, how you want to do them, and when.
Let's take a look at the estate planning tools. The first is the durable general power of attorney. The second point is an advanced care directive. The third is the HIPAA release and authorization. The fourth is a will. The fifth is non-probate transfers, and I'll have you be specific on that, and that is, there are four components to that: survivorship, beneficiary designation, transfer on death, and pay on death. And the last is living trust. So let's start at the top, and I have to say, when I first put this together, I simply had power of attorney, and you had me change that to durable general power of attorney. Tell me why.
Well, we never know, rarely do we know when we're going to need to rely on our planning, and rarely do we know what the facts and circumstances are going to be at that time. So if I, Ann, gave you my power of attorney and it was not durable, then you could act for me. But if I became incapacitated, your ability to act for me is incapacitated as well. So I want my power of attorney to be durable so that it will remain effective even if I'm incapacitated. And in fact, that's the primary reason I prepared it, so that my agent can go ahead and act for me. With regard to the general, as opposed to specific or limited, oftentimes people do a specific power of attorney so someone can sell a piece of property for them or act in a particular way for a particular finite period of time. But who knows how that document may be needed in the future. And so if we're picking people that we love, we trust, we fully expect that they're going to do the right thing when they act as our attorney in fact, then in many instances it's appropriate to have it both durable and general.
General. Very good. The second, advanced care directive.
This is medical planning. The issue here is if you're capable, of course, you're going to make your own decisions. But if you're unable to do that, do you have planning in place that appoints another person to be able to act for you? And have you made certain decisions that may be appropriate with regard to your own health care? End-of-life issues, organ donor, tissue donor, do you want to receive nutrition and hydration, etc.? What's important to you? Do other people know that? Incorporate that into your planning so those thoughts and desires are known, and that you've picked the appropriate people to act in the particular way that you want.
Now let's talk about something has been within the last decade, the HIPAA release and authorization.
Yeah, this document works in tandem with the Advanced Care Directive, wherein you name someone to make healthcare decisions for you. So it does not do me a tremendous amount of good if I appoint you to make healthcare decisions for me, but my healthcare provider won't share my private medical information with you, so you can't make good decisions. So a HIPAA release and authorization expressly releases my healthcare provider from liability, expressly authorizes my healthcare provider to provide this information to you as my healthcare attorney, in fact, so that there's complete exchange of information and you can then make better decisions for my welfare.
The will.
The will. The will is a probate document, and probate is the process of retitling assets from the name of the decedent to his or her heirs. But many things pass outside of probate, and that's that next bullet point you asked me to talk about. So things may pass by survivorship. For example, if you have joint owners on a bank account, upon the death of one, title vests with the survivor. You may have beneficiary designations, life insurance, retirement plans, etc. TOD, which is transfer on death, POD, which is pay on death, etc. So the will controls those assets that are subject to the process, probate process, upon the death of the decedent.
Okay, so really those two could have gone together, the will and non-probate transfers.
Well, you need to distinguish the fact that they're different. The will only control those things that don't pass outside of probate.
Got it.
And just be mindful. Oftentimes we see it, people will come in to update their planning and they've had documents prepared elsewhere and they say, oh, this spells out everything that's going to go. I want my life insurance policy to go to this person, and it's stated that in the will or something of that sort. But then there's a beneficiary designation, which is a contract between the provider. So upon receipt of my death certificate, pay to the person named in the beneficiary designation. It doesn't matter what it says in the will, because it's never going to get into that arena. So just be mindful that you have to coordinate the titling and distribution of your assets so that your probate estate works in conjunction with those assets that may not go through your probate estate.
Got it. And the last is the living trust.
Living trust. As persons, we all know we're going to die. We may become disabled. Living trusts don't. A trust, and there's so many different types of trusts, revocable, irrevocable, trust created during life, trust created during death, so you have to distinguish what type of trust we're talking about. But a living trust is a revocable trust. It's a trust we create during life, and it's an asset delivery vehicle. And it only controls the assets that are funded into it. So some people create a trust, but then they don't have anything in it. So if we create a revocable trust, we need to fund it. We need to put into it all of the assets that we can, by law, hold in trust. And then it's simply a timing issue. I control it when I'm able to do so. If I become incapacitated, I've named an appropriate person to act for me as a successor trustee. I've given them a scope with regard to how those assets can be distributed. Upon my death, I've determined who's going to administer things, how those assets that are in trust or directed to trust may be distributed over time, etc.
I do want one other point. We want to talk about support documents, and this is so important: the schedule of major assets and listing of key advisors and contacts.
Yeah, the idea there is oftentimes there'll be a death and someone will come in to start the administration process, and I'll ask them, is there any life insurance? I don't know, I haven't found it yet.
Right.
Some stuff's obvious, right? The
Right.
car's in the driveway and we know where the house is.
Right.
But bank accounts, brokerage accounts, notes receivable, annuities, real estate that may not be local, etc. So think about it. If you had an accident tomorrow and your successors had to walk into the house, is it readily apparent what you own or have an ownership interest in?
Right.
So to try to make things organized, we put together a schedule of assets and list that out, and then you just keep it current so that if you need to rely on the planning 10 years from now, you're not dealing with a 2009 document, you're dealing with a document that's current at that time.
At the time.
And the schedule of assets, or excuse me, the advisors and contacts. Married couples, sometimes there's not an organized telephone bank. So have you listed the family members on both sides to the degree that they need to be notified? Insurance agents, accountants, physicians, if you sold the house, who has the insurance policy on it, etc. What third parties may need to be contacted in the case of your disability, and of course in administering your affairs upon death.
And one quick question as we wrap up. The do-it-yourself kits, are they just as binding or is it necessary to involve an attorney when it comes to estate planning? We have about 30 seconds left.
Well, the do-it-yourself or the do-it-to-yourself, as we call them, you can in Alaska certainly do a holographic will. You can complete that. But the issue is, do you know what you're doing? Is the correct analysis undertaken so that the document will work the way you hope you want it to work, as opposed to just filling in the blanks and hoping for the best?
Wow. Wow. I want to thank our guest, Attorney Kevin Sullivan of Baxter, Bruce & Sullivan, for this overview, great overview of the importance of estate planning. To learn more about our topic of estate planning, visit our website at www.aarp.org. AARP is a nonprofit, nonpartisan member organization with 97,000 members in Alaska. AARP is dedicated to enhancing the quality of life for all as we age. We lead positive social change and deliver value to our members through information, advocacy, and service. AARP is offering free seminars on consumer protection and how to plan for a financially secure retirement. To find a free workshop near you, visit www.aarp.org/AK or call toll-free 1-866-227-7447. I'm Ann Seacrest. Thanks for joining us. See you again soon on AARP Alaska.
This program is made possible with funding from the Investor Protection Trust, the State of Alaska Division of Banking and Securities, and AARP,